jibber jab, bamboozle, nuka, noozle, bippity bop, she gone. You jibber jab, bamboozle, nuka, noozle, bippity bop, she gone. I mean, you keep on talking, but you don't know where to turn.
Good evening and welcome. I'm John Caldera, president of the Independence Institute. You're watching Independent Thinking. Well, congratulations. It's legal now. You have an individual right to keep and bear arms. So says the Supreme Court. I got to tell you, I'm very proud. Our very own Dave Kopel, who's been working on Second Amendment issues now for what, 300 years now?
Yes.
Actually, you've been doing this for what, 17 years?
I started Independence in '92, so 16 years, I guess.
You run our Second Amendment project, and this has really been a culmination of over a decade's worth of work.
Absolutely. I mean, really three decades worth of work for some of the people who started off on it in the early days, like Stephen Halbrook, the attorney who wrote the brief for the majority of Congress, and lots of other folks. It's been a long time coming.
In short, you must be thrilled of this Second Amendment case, the Heller case coming out of D.C.
You bet.
And from the Million Mom March and also the Brady Campaign, Pat Kramer, I'm wondering if you're very thrilled with this decision or not, since I'm just telling by the buttons on your blouse there,
like
stop gun violence, no guns on campus. What was your take on the Heller decision?
Well, at first I was very disappointed, frankly, but then some things have come about that I will discuss in a little bit, probably, that indicate that it wasn't quite the total all-out 100% victory that many people are claiming it to be.
Well, I tell you what, let's talk a few specifics first.
Good idea.
There hasn't been a U.S. Supreme Court decision on the Second Amendment in any sizable way for nearly 80 years. So this was a definitive and remarkable case. Tell me how big this victory was to those of us who are gun owners.
Oh, I think it's a very important one. It certainly isn't something that wipes out all gun control, but it's a strong recognition of that right. And as you said, there hadn't been a major Supreme Court case on the Second Amendment since the Miller, U.S. versus Miller in 1939. And over the years, there had been probably 24 cases since then where they mentioned the Second Amendment in some kind of minor way. And almost all of those recognized the Second Amendment as an individual right. But this is a huge opinion. And Justice Scalia's opinion was about 60 pages long, and the dissent by Justice Stevens was big, and so was the dissent by Justice Breyer. So this was a huge, major landmark
What made it big?
Case.
What made it a landmark case?
Well, it ends this argument that's been going on really since the gun prohibition movement got going several decades ago of trying to tell people that the Second Amendment is not an individual right. You know, there was this claim that, oh, even though it says right of the people, that really means it's a collective right of state governments. And, you know, that was, all 9 justices found that to be preposterous and just brushed it aside.
So is it fair that if somebody says, oh, there's not an individual right to keep and bear arms, we now have proof positive, yes, the Supreme Court has recognized our constitutional right to keep and bear arms as an individual right?
Well, all 9 justices agreed that it's an individual right. And so, you know, these years of people in the various gun ban lobbies saying, no, it's a collective right and it's so obvious, it turns out they were wrong, at least according to the unanimous Supreme Court. And then there was a dispute within the 5-4 about, is it a normal individual right for all the people, or is it something that only exists when you're on duty in a state militia? That's what the 4 dissenters thought.
Okay. Let's bring it over here. Let's focus on that issue of an individual right to keep and bear arms. The Supreme Court says that we all have an individual right, that we, the people in the Second Amendment, is no different than the people in the First Amendment. Good decision or bad decision?
Like the First Amendment, it is not a complete and total right to bear arms any more than it's a complete and total right to free speech. We all know there are limitations on that, the fire in the crowded theater thing. The Second Amendment is not unlimited. Again, you quoted Justice Scalia. His majority opinion states the right secured by the Second Amendment is not unlimited. This, I'm quoting him. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. So there is much more nuance than I'm hearing from you, and I think the nuances are important.
But I asked about an individual right to keep and bear arms. As a representative from the Million Mom March and Brady Campaign, is this Is this a good news for you? Is it something that you've already recognized? Is it something that the Brady campaign says this is a terrible decision? I mean, do you agree with the Supreme Court that we all have an individual right to keep and bear arms? So the Second Amendment talked about individuals.
I can speak to that on two levels. I personally don't want anybody carrying a gun ever, anywhere. That's me, Pat Kramer, talking. Now I'll talk about Brady.
Okay.
I think it's important to keep those separate because I don't want to misrepresent Brady or a million moms. There are so many individuals out there who should not have guns, and the people said on the Supreme Court, felons, mentally ill, children carrying firearms into schools, government buildings, and so forth. And someone in an article I read thought it was interesting that the Supreme Court is still protected from people carrying guns because there are no guns allowed in the Supreme Court buildings. So it is not an absolute right. Therefore, if it were an absolute right and they said you can carry guns anywhere, anytime, for any purpose, obviously I and Brady both would be very upset and very unhappy and dashing madly to the courts to take care of that. It is not an absolute right, any more than any of our other rights are absolute.
When you talk about that, I remember hearing this argument all the time, that it's not an individual right, that it didn't mean, when the Second Amendment said the right of the people to keep and bear arms, that little precursor clause about a well-regulated militia, really they were talking about state militias, armies. Haven't the Brady campaign and others said that it hasn't really been an individual right?
Well, the position of the Brady campaign, at least since they started actually intellectually engaging on this issue in the, I suppose, the late 80s, was they would take the view that's expressed by the Stevens dissent, which is an individual right of infinitesimally small proportions. It somehow exists only if you're on active duty in a state militia, and they're not even really clear exactly what the federal government can't do then, of course, because federal powers over the militias are so strongly stated in the main body of the Constitution. But they did, to their credit, at least say individual right. Certainly, if you look at the litigation stances they took, they vehemently opposed what the Supreme Court did here, and they wanted the court to say that, well, even though it says the right of the people, this really means only the right of the people in the militia, not the right of the people in general.
What statements did they put out?
Well, they wrote an amicus brief in the case, and you know, given the limited number of historical facts in their favor, they did a good job of marshaling the evidence. It was a well-written brief, and you know, certainly after this case came out, they were out there declaring that this actually helps their agenda. Although you'd think if it was so helpful, they might have been participating in the case on the other side. It's clearly a result that the Brady campaign has been working against for decades. And they wisely told Mayor Fenty in Washington, D.C., you lost the case in the Federal Circuit Court of Appeals. Just suck it up and change your D.C. handgun laws. Don't appeal to the Supreme Court because there's too high a risk that our side might lose, and the Second Amendment would be nationally recognized.
The Brady campaign suggested that D.C. change its laws when they lost on the appellate court or the D.C. court level. And the political folks there, the mayor said, no, let's bring it to the Supreme Court. And
yeah,
lost.
According to an Associated Press article from last October. Right. And the mayor's response was, well, you know, you may be right about the national, I'm taking a big risk for the national gun control campaign, but that's not my problem. I'm just thinking about Washington, D.C., and if I get any chance to win for D.C., I'll go ahead and do that, and I don't care what risks I impose on your national agenda.
Go ahead.
I just was going to speak to that.
Sure.
Because the Heller ruling just talks about the District of Columbia, a unique jurisdiction, which is not state nor federal, as we know, it does not decide the application of the Second Amendment to state gun laws. Okay? It's all kind of really muddy watered. You know, it occurred to me sitting here listening to you, it would help a lot if we knew whether the framers of the Constitution meant people to be a singular verb or a plural verb.
I think we have somebody who might answer that question. Let's bring it over here to our gun expert.
May I finish?
Let's answer that question, and then we'll get back to that one.
It's a noun, and what we know is, as the majority opinion in Heller points out, that every time it says right of the people in the Constitution, it means the right of all the individual